Hello, beautiful law school students. This is Leslie Juvenicare at the blog Law School for Visual Learners. I'm a 1L student studying along with you and getting through law school one class at a time. And I'm sharing with you an easier way to learn the law, and it's through visual learning. More than 60 to 80% of students are visual learners, auditory and kinesthetic learners, meaning that it's harder for us people to learn the black letter law the traditional way. And I'm here to show you that you can learn the law in an easy, simple, and fun way. So today we're going to do a part 2 of solicitation in co-ed crimes. I'm going to be talking to you about merger with that. So the last video we talked about solicitation and how that works. Now, what if the intended subject commits the crime? Then we're talking about accomplice liability. So we want to put that in our essay and make sure that we win all the points on our exam and on the bar exam. So I'm going to share with you my screen. Alrighty. So I'm clicking on my screen here. And so we talked in our last analysis here. What is solicitation? We said that solicitation has the mens rea and the actus reus. So the actus reus is requesting and encouraging another to commit a crime, and then the mens rea is with the intent that the person solicited commits the crime, whether or not they agree to do so. And so I gave you some analysis tips, and now we're talking about, well, what happens if the intended subject commits the targeted crime? So this section here is talking about accomplice liability. So in your essay, we're going to put accomplice liability. So here the guiltiness or the guilty criminal liability of the actual solicitor changes. It goes from the solicitor is an inciter and is liable as a party for the crime or attempt. So let's put that here. I'm going to underline that for you and highlight it. Oh, yes. Crime or attempt if the intended subject attempts or completes the target crime. So when you're doing your analysis in your essay, you're saying the solicitor is an inciter and is liable as a party for the crime or attempt if the intended subject attempts or completes the target crime. So in your essay, you put that as your rule, and then underneath there you say, you tell whether or not the intended subject made an attempt, ignored them, or actually completed the crime. So put that analysis of the facts, and then you say, okay, because they did that, and so it went from just the mere solicitation to a conspiracy or an attempt to do a crime, then this person is guilty as an accomplice for the attempted murder, the attempted burglary, or the let's say the rape of another person, and so therefore they would also be guilty as a party to the crime. So this begs a little bit more analysis. One who commits solicitation and then goes on to engage in further conduct constituting a conspiracy, attempt, or a completed crime probably cannot be convicted of both the solicitation and the conspiracy, attempt, or completed crime. So that's where solicitation is probably going to be a lesser included offense. So this is just modern way of looking at it. You know, this is not merger in the traditional common law sense, where let's say assault turns into a battery. We want to say that because the defendant may be charged and convicted of either the solicitation or the conspiracy. So always look at this one a little bit further when you're doing your analysis. When it's easy to say in your analysis, did they have the mind? Did they do the act? And then you have to go a little bit further because you're also in the hypothetical analyzing what did the other person do, the intended subject. You have to look at their crimes and if they're guilty or not of an attempt or an actual crime. It's important for us to analyze that. So, and then put accomplice liability and then flow from there. My phone went off. So I want you to take a good look at this component of accomplice liability, because every solicitation, attempt, conspiracy does have some form of accomplice liability, and it has to go inside your essay. So I hope this helped you in analyzing an inchoate crime and the actual accomplice liability, because you can't get away with one or the other. That's always going to be a discussion in your essays. So that's a key lesson that I learned today when I was studying and going over my outline, was to make sure that if you're going to analyze any inchoate offense, solicitation, attempt, conspiracy, remember merger, accomplice liability, or merger of that crime is going to be put inside of there. So that's a part of that analysis. So hopefully this helped you in any way. If you have any questions, please let me know. If you know better, if you're a law professor or a lawyer and you have a better way of learning this and mastering this, I invite you to share with us. I am a student. I'm just sharing along with you. This is not legal advice. I'm just a student working along with you because I love the law and it's fun to learn. And just as sure as you could learn to walk and talk and read and write, you can learn the law, and we're going to do it in a fun way. So thanks for joining us. I'm Leslie Juvenet at lawschoolforvisuallearners.com, and join us there for resources, books, tools, and outlines to help you learn law in a visual way. Learn it faster, learn it better, and join this community of law school students. Thank you so much. Have a great day.